legislature in 2019. We'll start with some things that are just in the news, a lot of fun stuff there. And then after we cover the legislative stuff, we will cover some significant cases that have happened in the last year. And so I hope you'll see what we deal with in the courts about how law is made, how it is applied to specific cases, how we analyze cases from a judicial standpoint. So I'm going to start by sharing my screen with you so that you can see what I would present to you on a screen if I was in front of you in a room. Let me get this started. All right. So there we are. There's the title screen. And as I said, we're going to start with breaking news. And we always have some funny breaking news. Florida man is a meme for a good reason. People in Florida just seem to keep getting in trouble. And in this case, in 2019 in June in St. Lucie, Florida, we had an outstanding intelligent person selling cocaine wearing a shirt that said Coke. There is precedent for this. In 2015, that guy on the right was selling drugs wearing a shirt that said, "Who needs drugs?" No, seriously, I have drugs. If they were smarter, it would make it harder for us, I suppose. But sadly, these things do happen. Now to a case that you may have seen in the news, and I want you to know the rest of the story. This is in Ames, Iowa, and a man was arrested for burning a rainbow flag. Now, I think what's upsetting about this case to a lot of people is, wait a minute, you can burn the American flag, you can trample on it and desecrate it, and there's no consequences for that. What got this guy in trouble was that they charged him with arson, not with just a flag offense in particular. Texas has twice tried to pass a law saying you can't burn a flag and make it a crime. And the U.S. Supreme Court one time and the Texas Court of Criminal Appeals one time said, no, that doesn't pass constitutional muster. But in this case, they didn't charge him with the First Amendment type thing. They charged him with arson. This guy was a real bright bulb, and he was caught in front of TV cameras, and he told the TV cameras that he had burned down their pride, plain and simple. He didn't like gay people, and he had been drinking in a bar and got upset and went down the street and stole the flag from the United Church of Christ and then burned it out there on the sidewalk, thus the arson charge. He had prior convictions for doing these kind of things, and it didn't help him that in front of the TV cameras, he said, there's nothing the judge can ever do to stop him. He's just going to keep doing this no matter what. Well, because of his prior conviction and criminal history, he was enhanced to a maximum range of punishment of up to 15 years, and he got an extra year on a misdemeanor charge and an extra 30 days on another misdemeanor charge. He'll have to serve 3 years before he is eligible for parole. That just goes to show how Iowa law can be a little bit different than other states sometimes. New York City got upset about hate speech, and they came up with their own law that said if you call someone an alien or an illegal alien, or you threaten to call immigration on them, and you do that with the intent to demean, humiliate, or offend them, then that is discrimination, and it is a fine-only offense, but they made the fine up to $250,000. I don't know who they're going after with this. My guess might be our current president. I don't know. I don't know that many people that can pay a $250,000 fine. Sure seems like a whole lot of money to pay for speech, but you better be careful what you say in New York City. Now, this is a really big danger. I know we're all very concerned about finger guns, but let me tell you, September 18th, 2019 in Overland Park, Kansas, a 12-year-old girl was arrested for unlawfully and feloniously communicating a threat to commit violence because she pointed a finger gun at other kids in her class. Apparently, another student had asked her, if you could kill 5 people, who would they be? And so using her finger gun, she pointed her finger at 4 other kids in the class and then turned it on herself. This got her arrested, and ultimately she was placed on some kind of a diversion, which would be a court-ordered supervision of some kind. So she did not go without escaping any punishment for this very silly little thing. Well, don't think this is just limited to little kids. This goes all the way to the top. I mean, look, there's our current president and our past president pointing finger guns. I don't know who they're pointing at. They didn't get in trouble for it. But in 2014, a 10-year-old Columbus, Ohio boy was suspended 3 days for pretending that his finger was a gun. And in 2015, a first grader in Colorado was suspended from school for making a finger gun under their zero tolerance policy. Strange times that we live in. Bail reform has been an ongoing thing, primarily in Harris County, Texas, is where we've seen it in Texas play out. There's been lots of protests. There was a federal lawsuit filed. Judge Lee Rosenthal was the U.S. District Judge sitting on that case. She issued an order that was in place for quite a while that forced Harris County to release everybody charged with a misdemeanor without bail. If they couldn't bail out in 24 hours, they got released free of charge. It didn't work out too well. They had a whole lot of no-shows. It was clogging the courts up. People were getting rearrested and immediately released again within 24 hours. It was not a good system. Thankfully, the lawsuit finally got settled. They have a new plan in place. Supposedly it's going to cost the Harris County $59 to $97 million. Those are the estimates. Pretty big range, but a whole lot of money. It was a 3-2 vote by the commissioners to approve the settlement. The district attorney opposed the settlement. Kim Ogg said that during the time that they operated under Judge Rosenthal's order to release everybody without bail, they had about a 59% increase in the misdemeanor dockets. It only applied to misdemeanors in Harris County. But this is a nationwide thing that we're seeing happen. And there are 2 other cases still pending in Texas, one in Dallas County and one in Galveston County. In September of last year, a federal judge in Galveston ordered that the county must start providing attorneys to people at the time that they are magistrated, which is called a 1517 bail hearing. We'll see how those go. The Dallas County and Galveston suits are different than Harris County in that they add felonies as well. And I can tell you in Lubbock County, this is not a problem. We're not doing things that they were doing that got them sued. But we're certainly paying attention and trying to make sure that we stay out of trouble, and of course, make sure that we respect people's rights. Now to get into a little funnier stuff, this really happened in Kansas. I'm sorry, actually it happened in Harlan, Iowa, but it was a Kansas man who was in a divorce lawsuit, and he filed a motion for continuance asking for 12 weeks so that he could obtain Japanese samurai swords. And then he wanted to fight both his ex-wife and her attorney to the death. He said that he wanted to, quote, rend their souls from their bodies. He said there's nothing in our law that prohibits trial by combat, but it hasn't happened here. I guess we haven't made a law against it because we haven't needed it before this time. The attorney on the other side for the ex-wife said that death from combat would probably outweigh the property tax and custody issues that were really at hand there. And the judge didn't take any action on it, but it was quite humorous. And it's not without precedent. In England in 2002, a guy got charged with a minor traffic offense. The fine for it would have been about 25 pounds sterling, probably a little over $30 here in the United States. And he filed a motion to challenge their Department of Motor Vehicles to appoint a champion and to fight him to the death in trial by combat with samurai swords, Gurkha knives, or heavy hammers. That didn't obviously happen. But the last known trial by combat in the English world happened in 1446. And there was a fight between a master and a servant to resolve the dispute. And allegedly the servant won because the master was drunk. But there hasn't been any precedent for trial by combat since 1446. Let's hope that doesn't come back. We have a much better justice system. You might remember this case, the guy that licked the Bluebell ice cream down in Port Arthur, Texas, and he posted a video of himself doing it. And the bad thing was he licked the half gallon of ice cream and then put it back on the shelf. Well, he got charged with criminal mischief because the store wasn't able to figure out exactly which carton of ice cream he had licked or whether he might have licked other cartons as well. And they had to throw out over $1,000 worth of ice cream. Now, he later claimed that after he pulled this little stunt, he actually took the carton of ice cream and paid for it. And he did have a receipt for a carton of ice cream that he was able to produce. But ultimately, he felt bad about it. He pled guilty and he got sentenced to 30 days in jail. So there was justice for the ice cream licker. The Money Doctor. William Gallagher was a guy in Dallas that had a show called The Money Doctor, and he advertised himself and gave financial advice out over the radio. But he also touted his Christian values and encouraged people to come see him personally. And he ended up bilking those people that were foolish enough to do so out of over $20 million. It was a Ponzi scheme. You know, he showed profits by taking new money in to pay back other people in a typical Ponzi scheme. He told people, you will never have to worry about money again. You can never outlive your income. I can give you returns of 5 to 9% a year, over and over and over. Well, he pled guilty. He got convicted in federal court. He got 25 years in prison. He's 79 years old, so chances are he probably will not make parole. But if he ever does, he is ordered to pay $10 million in restitution. Also in the Metroplex, we had a mayor of Richardson, Texas, one of the suburbs of Dallas, who stood trial, actually, for selling influence. She was apparently selling her vote as mayor and her influence as mayor for money, sex, lavish vacations, and a cushy job offer after she was done being mayor. She was tried and convicted, but her conviction was overturned because a bailiff was seen having an improper communication with one of the jurors during deliberations. So she's supposed to have had a new trial this summer, but COVID happened. So hopefully she will go back to trial next year. We'll see where that goes. But that's just something that's more in the news, not really precedential value yet. Here's a bright bulb who went to the Ohio bank and submitted a note to commit a robbery. You know, not all robberies are stick-ups with guns. Sometimes they just stick a note, I've got a bomb, give me everything in the cash drawer, whatever it might be. But this bright bulb wrote his stick-up note on the back of a form from the Ohio Bureau of Motor Vehicles. It had his name and his address on it. So whatever money he got away with, they found him 2 days later at his house, and he got busted. It's unknown whether he used any of that stolen money to purchase some new stationery. Hopefully he did. Or hopefully he reforms himself and quits robbing banks. Another brilliant criminal pretended to be a police officer. He had an emergency light on top of his vehicle and an air horn that he used to pull over another car. Unfortunately for him, the van that he pulled over was full of Nassau County detectives. And he then, realizing he had pulled over the real police, tried to run away, but they caught him pretty quick. And this happened in Hicksville, Long Island, New York. You can't make this stuff up. This guy in Alberta, Canada, went to a dispensary to purchase marijuana, which you can do lawfully up there. They have legal marijuana, but he presented a fake ID, and that's not okay. And here's how they discovered his ID was fake. First, it had a picture of Chris Hemsworth, the actor who plays Thor. The name on the fake ID said Thor Odinson, and the address said 69 Big Hammer Lane. The final giveaway, and who says pot doesn't make you stupid, he made a fake ID with an expired date on it. So you just crazy stuff. And then the last thing we have in the silly news segment is in Germany, a guy was sentenced to 12 years for bank robbery. He was 71 years old, and I'm guessing maybe he had some history. Don't know about that. But the judge said, like a lot of judges in America would say as well, do you have any last words before sentence is pronounced? He said yes, and then spoke for 5 days. That wouldn't go over too well in my court or any court that I know of. I don't know what kind of judge in Germany was so lenient to let him talk for 5 days, but I think he kind of filibustered his sentence. Sad thing for him, he still has 11 years and 360 days to go. Well, it wouldn't be a discussion of things that have happened in the past year if we didn't mention the COVID and how that has impacted the courts. For the first time in American history, the United States Supreme Court allowed argument by teleconference, just like we're doing this via Zoom. I don't know if they use Zoom or what platform they use, but something like this to hear argument of counsel and interact with the counsel. And another first, they allowed the session to be live broadcast audio only. C-SPAN carried the audio feed. They didn't allow video, but this was quite a first. And we've seen the same thing in the Texas Supreme Court, Texas Court of Criminal Appeals, 7th Court of Appeals in Texas, and I know other courts have as well. We have also actually seen a jury trial via Zoom, but it was not a trial. It was a show trial. It was kind of a demonstration. They used it as a way to see if they could convince the parties to settle. So they got some real jurors, and they really did try the case over Zoom, but it wasn't binding. It was more like a mediation in that way. It was an interesting process, and that happened in the Metroplex. There have been some municipal courts and some JP courts that have talked about doing this, and I think San Antonio is actually taking steps to make it happen. It may have already happened now, but I don't know of any district or county courts at law that are doing it yet. We've talked about it, but it's so hard to judge credibility and marshal evidence over electronic formats. Now we're doing lots of bench trials this way. I've had lots of family law hearings this way. We also know in the past year that we most recently lost Justice Ginsburg from the U.S. Supreme Court. She served 27 years. She was appointed by President Bill Clinton in 1993, and only the second woman to ever serve on the U.S. Supreme Court and the first Jewish woman. She had been first in her class at Harvard and Columbia Law Schools. She had been a professor of law at Rutgers University, an inspired advocate for the causes that she believed in. Of course, everybody I think knows she kind of fell on the far left of the political spectrum, but she was best friends with Antonin Scalia, who fell on the far right of things. And even though they disagreed greatly about legal constitutional interpretation matters, in some cases, I mean, Scalia himself, I one time heard him speak, and he said, we agree on at least 80% of things. It's only that 10 or 20% that we disagree on. But they were best of friends, and I think they were a great model for our country, and I wish we would follow them and maybe have less polarization and agree to disagree agreeably. But she was greatly admired and well respected, a trailblazer for sure, and she will be missed. Okay, Texas is a death penalty state. We utilize the death penalty more than any other state. In 2009, we executed in 2019, we executed 19 people. That was down from 13 the year before, but up from 7 that we executed in 2016 and 2017. In 2019, nationwide, 22 people were executed. Texas's 9 made up 41%, and that's pretty consistent. Interestingly, our death row population continues to decrease. At the end of 2019, we were down to 213 people on death row. That's down from 232 the year before. So we keep working that backlog down. We're not adding very many people to death row. In 2019, we only added 4 people to death row, meaning only 4 people got the death penalty. So we executed 5 more people than we sentenced to death that year. So we'll keep working the backlog down if we do that. This is a trend that we've seen happening since 2005, which happens to be the time when life without parole was created as an option. Prior to that time, life was really the same as 60 years. If a jury sentenced somebody to 60 years in prison, or they sentenced them to life, there was no difference. 70 years, 80 years, same thing, because of how the parole worked. And so even if you got a life sentence, you could be eligible for parole after 60 years. And now we have life without the possibility of parole, and we've seen a lot less death penalties handed down. In 2020, we only executed 3. Now, we were set to execute more than that, but coronavirus or COVID got in the way and kept us from doing more. Nationwide, there were only 7 executions, so our 3 made up 43%, very similar to that 41% the year before. Death row population is down to 211 from 213 the year before. So you can see that the trend continues. Now, isn't it interesting that even though we actually utilize the death penalty, we're 3rd in terms of the number of people on death row. California is number 1. California has 711 people on death row as of right now. Florida comes in number 2 with 338. But they're not utilizing their death penalties the way we are, so they're building up a backlog. I'm not commenting on the propriety of it, just the facts. Okay, 2019 was a legislative year. Our legislature meets for about 5 months every other year. And when they meet, they have one thing that they have to do, and that's pass a balanced budget. We have a balanced budget amendment in Texas to our Constitution. Of course, we amend our Constitution a lot, but we actually do require them to pass a budget and to pass a balanced budget. That's always the number 1 and biggest priority. And then other things come up from year to year. And this year, two big things that happened were property tax reform and school finance reform. They had to wrestle with almost 8,000 bills that were filed this year. Of those 8,000, almost 8,000, just under 1,500 actually got enacted. There were 144 bills that were passed and not vetoed, so they're part of the group that got enacted. And then there were 58 bills that passed and were vetoed, so they did not get enacted. Things that didn't pass that matter to us in the criminal world is, of course, perennially, there is a movement to reform our capital murder system and to do away with it. That failed. It usually does. It always has so far. There was an asset forfeiture reform bill that did not pass. It had a lot of traction, though. And we're going to talk about an asset forfeiture case when we get into the case law. There was a bill to reform grand juries that also failed. Bail reform, and that the Harris County bail litigation. There was a bail reform bill that had a lot of traction, but it did not pass. And there was a push by lawyers to say we should be able to enter the courthouse the same as the prosecutors. Most of the DA's offices are in courthouses, and they're able to come and go as they please, but the defense lawyers and the civil lawyers are not. And the state bar actually got together and made a big push and ran at the legislature and said, hey, lawyers have background checks. They're fingerprinted. They're officers of the court. They're not just the general public. We know who they are, and they're checked out. They ought to be able to come and go through security a little more easily. The legislature did not agree. There were two bills that actually passed but were vetoed. One would have standardized the plea forms that we use across the state. Right now, every county uses different forms. And I'm sure that's really difficult for the state agencies that have to collect all that data, as well as the Texas Department of Criminal Justice Institutional Division, what we call the prison system. If they're getting different forms from every single county, maybe even different courts in a county, that certainly has got to be a little bit hard to figure out. If they were all standardized, it'd probably be easier to read all of them. A second bill would have required that judges have legible signatures or print their name or type their name below their signature so we know who's signing it when they sign an order. Now, there's a separate statute that requires that we identify who the judge is when it comes to a warrant that is issued. But this would have been on all orders. And I don't know what the reasoning was for why that veto happened, but it got vetoed. So that did not pass. But let's talk about what did pass. Good old schoolhouse rock. So we had a capital murder bill that passed. It has always been a death penalty type murder if you do certain things. One, if you kill a child younger than 10 years of age. If you kill a police officer. If you commit multiple murders, or if you commit murder in the course of committing another felony, such as a burglary or robbery or something like that, even stealing a car. Evading arrest, if you murder somebody, could be a felony. If you evade with a vehicle, it is a felony. So under these certain things, then you are eligible for the death penalty. Otherwise, just regular murder is up to life in prison. Well, we expanded the death penalty, but we call it capital murder, but you only can get life without parole if you kill a child 10 to 14 years of age. So we expanded the protection for children, not with the death penalty, but it still falls under the capital statute. That's how you can get into the life without parole. So that's a little bit of expansion there. The legislature passed 5 bills having to do with sex crimes. The first one deals with DNA and lab testing. And we have found out that the labs have been sitting on a lot of samples, rape kits, whatever they might be, biological material that they haven't been testing, probably due primarily to manpower and money issues. And the legislature said, well, we're going to start getting that stuff tested. Now, notice that's going to begin January 1st of 2021. So that gives the labs some time to staff up and budget up, if the legislature will give them the money, of course, so that they can start testing these old rape kits and other information they have. Another thing they did was they extended the statute of limitations. The statute of limitations says charges must be brought within a certain amount of time. And they said, well, we will eliminate that limitation if there's biological material that's been collected and not tested, or it's tested, but we don't get a match to any known database of people. And then if later we get a match, that case could be prosecuted, even if it was years down the road and limitations would have otherwise barred it. So in the digital age, lots of things have moved to the internet, and pimping and prostitution is one of those things. And Senate Bill 20 criminalized pimping online, or the online promotion of prostitution. It's a brand new offense. It makes it a third-degree felony or a second-degree felony if you have a pimp who is running more than 5 prostitutes. They could be girls or boys, I suppose. Another part of this bill is interesting in that it mandates probation for prostitution convictions. So the prostitutes themselves, not the pimp, but the prostitute or the John, must get probation. Can't just give them time served. Well, a lot of them really don't want to be on probation, especially if they have a drug habit or something. They don't want to have to continually have a urine and drug test or anything like that. So I don't know how well this is going to work out. And in addition, they mandated that each county will create a commercially sexually exploited persons court program. It's going to be a probation program that we're going to work with the Johns and the prostitutes, and hopefully put a stop to prostitution, although it seems to go way far back in history. I don't know if we'll ever cure it, but we're going to work on it. Revenge porn has been a sticky wicket for the legislature. In 2015, the 84th legislature criminalized revenge porn. This is where, typically couple breaks up, he still has pictures of her that are inappropriate, and to get back at her, he shares naked pictures of her with the intent to harm her. When they passed the first law in 2015, it made it a crime to unlawfully disclose intimate visual material, to threaten to disclose it, or to promote the disclosure of it, meaning to repeat it. If your buddy sends you the naked pics of his ex-girlfriend and you send them on to somebody else, now you're committing the crime as well. Well, that law got struck down as being unconstitutional in 2018 by the Tyler Court of Appeals in the Ex parte Jones case. Note, Ex parte Jones is up on appeal at the Court of Criminal Appeals. They took it up on petition for discretionary review, and we're still waiting for that decision. They've had it since 2018, and I don't know when we'll get an opinion out of them, but we're looking forward to it. In the meantime, the legislature came back in 2019 and changed the law under House Bill 98. And this time, one of the things they did is they inserted language that says, with the intent to harm a person. It didn't have that before. And so that narrows the statute a little bit. That prevents somebody being criminalized for accidentally doing something. We'll see if that passes muster or not. They created a new offense that I call groping. It's titled indecent assault. Assault is generally, we think of it as you hurt somebody and they had to feel pain. But there is on the books an assault that's a Class C misdemeanor called unwanted contact. And so now they're going to change that a little bit and make it a Class A misdemeanor if that unwanted contact touches their naughty bits. So if you grope somebody by touching their naughty bits or touching them with your naughty bits, don't rub your naughty bits up on somebody else if they don't want it. It has to be without consent, and it has to be with the intent to arouse or gratify the sexual desire of yourself or someone else. Then that's a Class A misdemeanor, and you could go to jail for up to a year or up to $4,000. Now, fortunately for the Harlem Globetrotters, they didn't outlaw pantsing. Here again, no intent to gratify sexual desire, just to embarrass and humiliate. And at least in this situation, the poor Washington Generals player did not have his genitalia or naughty bits exposed. So thank goodness the Harlem Globetrotters and the Washington Generals can still entertain us. Sexting is now a crime. This is where you're texting naughty pictures. And it is a crime if you do so without consent. And what you send depicts the exposed genitals or the covered genitals of a man in a discernibly turgid state. I really don't want to think about that. But it is a crime to do this. And so don't send naked pictures unless they're wanted. I would say don't send them at all, but certainly don't send them with unsolicitedly. You could go to jail for that. We had 4 weapon offenses bills, 4 bills related to weapons offenses that were passed this year. The first one extends the castle doctrine to leased dwellings. So you've been able to possess a weapon in your own house. But what if you were leasing an apartment and the landlord didn't want you to have a weapon there? They just don't like weapons or whatever it is. Well, the legislature said, too bad, landlord, you can't keep people. If that's their dwelling, even though they might just be a leased tenant, they can keep a weapon there, whether the landlord wants to or not. They also extended this to churches. Previously, churches had been a place you couldn't carry weapons, and now they said, well, you can, so long as it's okay with the church. So churches can prohibit it. If they don't, then it's okay to carry a weapon in church. I'm sure that might have something to do with the Sulphur Springs church shooting. Don't know for sure, but I imagine. They also created a defense for license to carry holders. You know, some people say CHL, or concealed handgun license, but it's actually called a license to carry in Texas. If you are a license to carry holder and you're lawfully carrying and you walk into a place that you're not supposed to carry a weapon, and you do it by mistake and you immediately realize, oops, I shouldn't have walked in here. If you turn around and go back out, that is a defense to being prosecuted. And so it's kind of no harm, no foul. We won't take your license away and put you in jail for doing that. And then finally, they legalized the carrying of brass knuckles. Now there's some history here. In 2013, they legalized switchblade knives. In 2017, they legalized knives longer than 5.5 inches and swords and machetes to be carried. And so now I guess it was inevitable that brass knuckles be legalized as well. Apparently it's a self-defense thing. I just hope they don't start showing up in Happy Meals. 2 bills were passed this session that relate to driving while intoxicated. The first one is we finally got deferred adjudication for DWI. DWI has been the only crime that you could not get deferred adjudication. Deferred adjudication is a type of probation in which you admit your guilt and the judge makes a finding that there's enough evidence to find you guilty, but puts off actually finding you guilty and puts you on community supervision. And if you live it out, then you get the case dismissed. If you don't live it out, that finding that the judge made is sufficient for the proof to be had of guilt. We don't have to go retry the offense. You pled to it, and the judge made the finding. So then it's just a matter of what the punishment would be if you violate it. There's one that's been kind of different, and that's been domestic assault. If you got it deferred on a domestic assault and lived it out and got it dismissed, and then later committed a second domestic assault, that would reactivate the first one, and the first one would be treated as a conviction for purposes of the second domestic assault, which enhances it to a third-degree felony from just a Class A misdemeanor simple assault. The DWI is going to be the same way. Now, if you get deferred on a DWI and you live it out and you get it dismissed, but you get another DWI down the road, we can treat that second one as a true second, just as if the first one had been an actual conviction. There's a couple other limitations to it. It only applies to first-time offenders. You cannot get deferred if you're a second or a third DWI or more offender. You cannot get it if you have a commercial driver's license, even if you weren't driving your commercial vehicle at the time. Even if you're driving a civilian vehicle, if you have a CDL, you cannot get deferred on a DWI. And you cannot get deferred on a DWI if your breath or blood alcohol content is greater than 0.15. The legal limit is 0.08, so 0.15 is almost twice the legal limit. Interestingly enough, we're finding out with a lot of first-time offenders now that we're getting so many blood tests because of search warrants, 0.15 to 0.17 is a really common breath alcohol content. So it's only going to apply to offenses that occur after September 1st of 2019, because that's when the law went into effect. And I will tell you that Mothers Against Drunk Driving supported this. They felt like it would help hold more people accountable and that it was a good thing. So that's why it finally got passed. The other thing that the legislature did is they eliminated surcharges. And if you're not in the criminal world, it might not be something you know a lot about, but they had these surcharges that were tacked on to your driver's license suspension that you had to pay if you got convicted of a DWI. And they used a lot of that money to fund hospitals and emergency rooms. But there was a lot of fuss about it, and everybody thought it was really terrible. So they got rid of the surcharges and came up with fines. Now you get to pay an extra fine of $3,000 on a first offense, $4,500 on a second offense if it's committed within 36 months of the prior, or $6,000 if your breath or blood alcohol content's over 0.15. However, that only goes into effect if your conviction becomes final, meaning you serve jail time, not just get probation. I'm not talking about shock time. I mean, you just get a straight jail sentence. If you get a straight jail sentence, then you got to pay this fine as well. But you have an opportunity to show the judge that you're indigent. The burden is on the defendant to make that showing. And if so, then the judge has to waive the fine. And again, this is only for offenses after September 1st, 2019. So we're kind of coming up on the time now when a lot of those are starting to come through the court, and we're going to have to deal with quite a bit of them. It'll be interesting to see how many people actually are able to pay these fines, but we have to deal with it. Okay, we have still not legalized marijuana in Texas for recreational use, and we really hardly have medical marijuana. We have had medical marijuana in Texas in the past, but only for intractable epilepsy, which is epilepsy that does not respond to treatment by any other drugs. And it took 2 doctors, one of them had to be a neurosurgeon, to sign off for you to get the medical marijuana. And the marijuana that you can use under this law was very weak. Well, we've expanded medical marijuana just a little bit, not much. Now it can also be used for regular epilepsy, multiple sclerosis, and spasticity. It only requires 1 doctor, and they don't have to be a neurosurgeon. And it is specified that the marijuana that you can use, if this is prescribed to you, has to be less than 0.5% tetrahydrocannabinol or THC content. So you can't get medical marijuana for glaucoma, back pain, or a myriad of other things that you can in some surrounding states, but you can get a little bit more of it for epilepsy and MS and spasticity, and get it a little bit more easily. The other thing we did was we tried to help farmers to say you can farm hemp. But the problem is hemp is a plant called Cannabis sativa L. Marijuana is a plant called Cannabis sativa L. They're the same plant. What makes the difference is the THC content. And so the legislature came up with a rule and said if it's Cannabis sativa L and the THC content is less than 0.3%, then it's hemp. It's for farming purposes. It's for agriculture. We can make rope and clothes and whatever out of it, and it's perfectly fine and legal. Well, I guess that means marijuana is now Cannabis sativa L that's over 0.3% THC content. The unforeseen problem is our labs are not set up to test for content. They test for what it is. It's Cannabis sativa L or it's not. But they've never been able to quantify that. Now, it can be done. Our labs are just not equipped to do so. So they're spooling up and trying to get ready to do that, along with getting ready to test all the old rape kits and everything else. And of course, the courts are throwing more and more warrants at them for blood testing, or the police, law enforcement are. So our labs are really burdened right now, but this is just one more fun thing they get to deal with. Then we have 4 bills that I would say fall into the category I'm just going to call miscellaneous. We raised the smoking age to 21 not too long ago. We've raised the vaping age to 21 as well. We have made it a felony to be a porch pirate, and thank goodness for this, I think. This was really just broadening a rule that was a little bit too narrow for the times. Theft of mail has been a felony, but it was mail in a mail receptacle. And yet so many people in the age of Amazon and everything else are getting packages that don't fit in the mailbox. They're coming like mail, but they're being left on the porch. And so now we've expanded the premises to be the premises, the porch and the other places where these articles might be left, and the definition of mail to include these other kind of articles. So porch piracy can now be a felony. We've outlawed red light cameras. We had different cities doing different things around the state, and the legislature finally came and said nobody may have red light cameras anymore. Those of you that have red light camera contracts, you can let the contract run out. You don't have to cancel it. But once it runs out, no more red light cameras. That's the law of the land in Texas now. And we've tried to protect our citizens from spoofing, which is when somebody fakes their caller ID. So you get that phone call, you look at your phone, it comes up with a number that looks like a local area code, you answer it, and it's a scam call or something you don't want. Well, they're not supposed to be able to do that anymore. They can't disguise their caller ID. It's a Class A misdemeanor to fake that. I don't know how they're going to enforce it. I don't know what it would take to go back and catch the people that are doing it. I think it'd be very difficult, but that's the law. All right. Now moving into case law. And this is where there's been something happening in a trial court, usually a trial and a conviction and then an appeal, but it could be a writ of habeas corpus that could happen in the middle of a trial or something else. And so these cases come out of trial courts. They go up to appellate courts. In Texas, we have an intermediate court of appeals. We have 14 of them. One in Amarillo, serves the Lubbock area. There's 2 in Houston. They have the 1st and the 14th. And then the others are scattered around the state. And then we have the Texas Supreme Court that hears all the civil, family, and juvenile matters. And we have the Court of Criminal Appeals, which is a co-equal Supreme Court of Texas. We're one of only a couple of states that have 2 Supreme Courts that way. But it only hears criminal cases. So a criminal case would ordinarily make its way from a trial court to an intermediate court of appeals to the Court of Criminal Appeals. Civil cases do the same thing. They just end up in the Texas Supreme Court. Then, of course, you have the federal trial courts and the circuits of courts of appeals for the federal circuits that cover multiple states. We're in the 5th Circuit. And then they go to the U.S. Supreme Court. Cases that they go all the way to the Texas Supreme Court or the Texas Court of Criminal Appeals can also go to the U.S. Supreme Court. And so we're going to see some appellate opinions at all levels. We're going to cover 10 different areas of cases, 6 areas covering under certain amendments to the U.S. Constitution and the Bill of Rights, then some evidentiary issues, a category that I just call cases that make you say, duh, we should have known better, and then miscellaneous, and finally, cases to watch if we have time. So turning to the First Amendment, which protects us free speech, freedom of religion, freedom of assembly, freedom of the press, all very important things. And we have a couple of cases here. This is an interesting case that you may have heard of. It made the news nationwide. It's U.S. Supreme Court turned this case down. So it's not a U.S. Supreme Court opinion, but it certainly made the news a whole lot. And I'm not sure where it leaves us. Here's what happened. That fellow on the right is dead. He committed suicide. He was 18 years old. He sat in his vehicle in a Kmart parking lot in Massachusetts somewhere and breathing carbon monoxide in his car. I assume he ran a hose from the exhaust pipe. I don't know. The girl on the left was his girlfriend. She was 17. She encouraged him to do this. She had sent him text messages in the days leading up to his death, encouraging him to kill himself and telling him not to wuss out, to go through with it, be a man. On the day that he was actually doing it, he got out of the car and he called her and she told him, get back in the car, kill yourself. And he did, but not before texting a friend and telling his friend that she had told him to do this. The police didn't have a recording of the phone conversation, but they had the text message where he had told his friend what Carter had told him. So he got prosecuted. He's dead. She got prosecuted in Massachusetts for involuntary manslaughter and got convicted and was sentenced to 15 months in prison. Of course, she appealed. And she appealed to the Massachusetts Supreme Court. She had lost at all those levels. She petitioned the U.S. Supreme Court to take her case. The United States Supreme Court only takes the cases that they want to take. That's why you petition them for writ of certiorari. And they decide to grant or not grant, and it's a very, very unlikely chance that you ever get a writ granted. They don't decide a lot of cases. Last year, the U.S. Supreme Court decided 54 cases. That was it. They had thousands that asked their cases to be taken up, but they only decided 54. So it's hard to get it done. Her lawyers were arguing this is a First Amendment issue, free speech, even deplorable speech. They said words alone are not enough to hold someone responsible for another person's taking their own life. But Massachusetts said words were enough, and the U.S. Supreme Court let that stand. Then we have 2 cases in Texas on harassment. We have a harassment statute in Texas that says you're not supposed to say obscene things. Now, this is a limit on speech. Generally, you can speak freely most of the time, but we know there's a few things that you can't do. You can't shout fire in a crowded theater. You can't make threats against somebody else, and you should not harass people. Harassment is speech that's designed to harass, annoy, alarm, offend, torment, or embarrass somebody else. And the 2 cases we're going to look at here deal with the obscenity side of harassment and then with just more of a behavior side of it. The first case, and we have different results, and by the way, both of these cases have been granted petition for discretionary review. So our Court of Criminal Appeals, much like the U.S. Supreme Court, decides which cases they take. And instead of issuing a writ of cert, they grant discretionary review. And so you petition for that. In the Nuncio case, the victim went for a job interview at a restaurant. the guy that owned the restaurant was a creep, and he gave her a 2-hour interview, during which time he stared at her breasts and he made comments like, "Are those D's or double D's? What do you like to do sexually? Do you like to party? Do you have a boyfriend? Do you have sex with your boyfriend? Hey, why don't you have your boyfriend come down here to the restaurant and y'all can go have a quickie in the back? I don't let any virgins work here." I don't know how she sat there for 2 hours listening to this kind of stuff, but afterwards she went to the police and she said that Nuncio's actions were harassing and she was offended. Um, Obscenity under the harassment statute is defined as a patently offensive description of or a solicitation to commit an ultimate sex act. And it really goes into some gross descriptions of things. You can look that up if you want to. I won't do that here. Nuncio said, hey, this statute's overbroad. It sweeps in lawful conduct and accidentally perhaps, but still criminalizes it. And that therefore it's facially unconstitutional and it should be struck down. The trial court denied his writ of habeas corpus seeking to strike down the statute. It went to the San Antonio Court of Appeals and they agreed with the trial court. They said the statute's okay. The San Antonio Court of Appeals did a good job looking at history. And they looked at a very famous U.S. Supreme Court case called Miller versus California, which set out a test that said whether the average person in that location, not the average person somewhere else, an average person in San Antonio at that time, not in the 50s, not what standards might be in the future, but at a contemporaneous time, would they find that the speech in question here appeals to prurient interest? Secondly, does it depict or describe in a patently offensive way sexual conduct? And thirdly, whether taken as a whole, does it lack artistic, literary, political, or scientific value? If it doesn't pass all of those tests, then it's not okay. There previously had been some law that looked at potentially obscene things and said, are they utterly without redeeming social value? And that was too difficult of a test to apply because social value can be found in so many different ways. You know, beauty is in the eye of the beholder. The Miller court rejected the without redeeming social value test and reaffirmed Roth, U.S. versus Roth. And you probably don't know the name U.S. versus Roth, but you're going to know what I say next. U.S. versus Roth is one of those Supreme Court opinions that everybody knows, but not for why they think they do. They don't know it for the primary holding. There was a concurrence to the main opinion by Justice Potter Stewart. And he said, I'm not able to define obscenity, but I know it when I see it. That's a difficult legal standard to apply. And we should be glad that's not the law of the land today. As a professor named Goldberg put it, I know it when I see it, and someone else will know it when they see it. But what they see and what they know may not be what I see and what I know. And how on earth will we ever enforce that? It would be very difficult. But ultimately, the San Antonio Court of Appeals, looking at all this precedent, said that in this case, the harassment statute is not overbroad. It does not prohibit a substantial amount of protected speech. It merely prohibits unprotected obscenities that are intended to harm someone against who they are directed. And the person in this case, Nuncio, was not engaging in legitimate communication of ideas. He was just being a creep. And so they said it was okay. The Court of Criminal Appeals has taken this up, and we'll see what they do. Fort Worth Court of Appeals had a different case. In ex parte Barton, we again have the harassment statute being challenged. But in this case, Barton was sending text messages and emails and who knows what else to his ex-wife. And he was doing it over and over and over. And her phone's going ding, 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 and her email inbox is just filling up. And it was very annoying. And it might have even been alarming. It was certainly abusive. Perhaps it tormented her or embarrassed her. All those things that the harassment statute covers. But here we're not looking at the content of the speech. It's more of a behavioral issue. Barton said the statute is vague and overbroad. And the trial court agreed with the victim and with the state and denied the writ, but the Fort Worth Court of Appeals reversed. The Fort Worth Court of Appeals said the statute was vague and overbroad, and that it was too much. They said, can we really criminalize annoying behavior without any objective measurement or standards? How do we know how much is too much? An eggshell victim might be annoyed by a single text. Somebody else could ignore 1,000 texts and not think anything of it. This is too overbroad and too vague. And that case is also going to go to the Court of Criminal Appeals. We'll see what they say about harassment. Um, this is a revenge porn statute. Now we have the Jones case that's up on appeal that we're still waiting from 2018 to see what happens. But this is a case that came out after the legislature changed the law. And in here, we have a writ challenging the statute that prevents you from disclosing or promoting intimate visual material. When we look at these statutes, now we're looking at a content-based restriction, and that's going to be subject to strict scrutiny. We got to make sure that the First Amendment to free speech is not impinged. In doing this kind of analysis, the legislature is the court is going to make sure that the legislature did not act unreasonably or arbitrarily. Normally, the burden is on the person challenging the statute to establish that it is unconstitutional. We presume that the legislature does constitutional things. However, when a statute restricts and punishes speech based on content, the presumption is reversed and the burden is reversed, and it is on the state to show that the government acted lawfully in passing the statute and rebut the presumption that it is unlawful when it restricts content. We talked about it has to be narrowly tailored to serve a compelling state interest, and that interest has to be justified. Here we have the Waco Court of Appeals. So we have San Antonio, we have Fort Worth looking at whether the harassment statutes are valid. Now we have the Waco Court of Appeals looking at the revenge porn statute, and is it subject to strict scrutiny? And what the Waco Court of Appeals said is the statute was narrowed to content created under circumstances in which the person who is depicted in the picture had a reasonable expectation of privacy. Also, it's narrowed because the picture has to depict the person. It can't be, like just a shot from the neck down, although even that could depict a person if there are identifying marks, tattoos, or something else where somebody else could look at it and go, I know who that is. So it has to reveal the identity of the person depicted, and it's narrowed, but because the disclosure of the statute doesn't have to be just accidental, it has to be intended to harm the victim. Because the legislature wrote those things into the statute, they narrowed its focus to a compelling state interest, which is to protect people from unwanted disclosure of their intimate visual material. And so the Waco Court of Appeals said that it was not unconstitutional, unconscionably overbroad or vague in violation of the First Amendment, and the conviction stands. And that hasn't been appealed, so that's good law, at least in Waco. Okay, moving from the First Amendment to the Second Amendment. Second Amendment protects our right to bear arms. And we have a case out of the United States Supreme Court that is not an opinion in the way that some people really wanted it to be. New York City passed a law saying if you're going to have a handgun in New York City, you have to get a license. There's two kinds of licenses that you can get. A carry permit, which allows you to carry it around anywhere you want to. Those are very hard to get. Or a premises license. That allows you to have that handgun at one specific location to protect yourself, at your home typically, but possibly your office. They also allowed you to transport your firearm within the city limits of New York to take it to a rifle range or pistol range and practice with it. You had to transport it in a locked container. It had to be unloaded, and you had to transport the ammunition separately from the weapon, not in the same container. Well, there were three plaintiffs that came together and said, we want to take our handguns that we lawfully own, they're licensed, premises licensed, but we want to go outside of New York City and go shoot at a range somewhere else, or engage in a shooting competition somewhere else, or somebody had a second house in Montauk or Nantucket or somewhere else, and they wanted to take the weapon with them when they went to that house. They couldn't do it under the New York City law. So they brought suit, and they were assisted by the New York State Rifle and Pistol Association. They lost in the federal district court for the Southern District of New York. That got appealed to the Second Circuit Court of Appeals for New York in that area, and they lost there too. So they petitioned the United States Supreme Court for writ of certiorari and got it. It was granted. Well, as soon as the Supreme Court granted cert, New York City changed their law and then demanded that the U.S. Supreme Court dismiss the case as moot. No longer an issue for you to decide. We've changed our law. It's moot. The plaintiffs objected vehemently. They said, no, we absolutely want you to rule on this issue. Our rights were violated, and we haven't been made whole again yet. Plus, there's still some issues. The way they changed the law is still of concern because they said now we can transport the pistol outside of New York City, but we have to engage in uninterrupted travel to our destination. Well, what if we need to stop and use the bathroom or eat a meal or take care of a dirty diaper or who knows what else? That's interrupted travel. That's again, impinging on our Second Amendment right. And by the way, they brought this case not only under their Second Amendment rights, they also said that the New York law had been a violation of the Commerce Clause and of the constitutional right to travel. Well, in a close decision, the U.S. Supreme Court did ultimately dismiss the case as moot. And they said the rules of mootness are what they are, and the other issues, the way the new law is drafted, that wasn't argued below. And so until that is argued and developed factually and legally below, it's not proper to be in our court. This was very controversial. Chief Justice Roberts joined the opinion. Nobody claimed it. It's a per curiam opinion. But it is joined by Chief Justice Roberts and Justices Ginsburg, Breyer, Sotomayor, Kagan, and Kavanaugh. There was a strong dissent by Justice Alito, joined in full by Justice Gorsuch, and in part by Justice Thomas. Justice Kavanaugh concurred to say he agreed with everything Alito said in the dissent, but the rules of mootness are the rules of mootness, and we have to follow procedure. But he didn't like the result. In the dissent, Justice Alito points out that not only are these other issues still remaining, and when it comes to mootness, if 90% of the issue goes away, but there's still 10%, there's still something for the court to decide. There's still a justiciable issue. But something else is also afoot. By dismissing the case for mootness, they don't get to remand it back to the trial court to have a hearing on damages or the award of attorney's fees. So these plaintiffs who have spent all this money to try to be made whole and to get the law changed and have their rights protected don't get any chance to recover what they've spent going forward because they didn't win. They got the appeal dismissed. The other side did. They got the law changed, but they don't actually get to sue for their damages because they didn't get remanded. So it's very controversial. You know, there have not been a whole lot of Second Amendment cases. Heller is pretty recent. You go back in that, there's not a whole lot out there. The new present nominee for the U.S. Supreme Court, Amy Coney Barrett, has been asked about this and has talked about it. And she actually has written on some Second Amendment stuff, and it's very interesting to hear her talk about it. And she says, there's not a lot out there on this. And so Second Amendment advocates would like the Supreme Court to take more of these cases, but they didn't do it in this case. So there's that. And we don't usually have a whole lot of Second Amendment cases, but we have a lot of Fourth Amendment cases. Fourth Amendment and Sixth Amendment are where we get the most cases. And the Fourth Amendment deals with search and seizure. And remember, it's what the government can do to you, not just about private individuals. In this case, the first case that we have is Kansas versus Glover. And the United States Supreme Court case, a strong decision, 8-1. Sotomayor was the only justice who dissented. In this case, the question, or the facts are that a police officer was following a vehicle, ran the license plate, they do that, and the license plate came back to Glover as the registered owner, and it turned out that Glover had a suspended license. So the officer initiated a traffic stop, reasonably inferring, he thought, that Glover would be driving the vehicle that Glover owns. And that was the entire issue that went up before the U.S. Supreme Court. Is it reasonable for an officer to assume that the vehicle is being driven by its registered owner? Because you can't tell most of the time, looking into the back of a car, who's driving. And the U.S. Supreme Court said, yes, we trust officers when they're making brief investigative stops to use their common sense and their experience to make judgments and inferences about human behavior. And in this case, the officer's judgment was based on common sense and experience. So, you know, if the officer had stopped the car and it turned out it wasn't Glover driving, and whoever was driving was lawful, then they would have let him go about their business, and that would have been fine. It was a brief investigatory stop. So that is a reasonable inference, and that is allowed under the Fourth Amendment. When we talk about the Fourth Amendment, reasonableness is the most important word that we need to keep in our vocabulary. That's what the court always looks at. Is this reasonable from an objective, reasonable person standpoint? The next case, I am surprised, is not designated for publication. This is a Texas Court of Criminal Appeals case. And I'm surprised it wasn't designated for publication, because I know there were a lot of attorneys all over the state watching this case, and arguments were being prepared to be made in lots of other cases had this turned out differently. In the situation here was we had a DWI, and then we had a search warrant to get the blood, because the guy refused to provide the specimen of breath or blood. And so they got a search warrant by a magistrate, and that was all done properly. The only issue was sort of a technical one, in that the warrant authorized the drawing of the blood. It didn't authorize the testing of the blood. And Kreider said, well, when the DPS lab went and tested it, they did so without a warrant. That's inappropriate. And the court said, no, it's really not, because it's reasonable to presume if you draw blood for the purpose of testing it for blood alcohol content, you're going to test it. It's implied, even if it's not stated absolutely. So that's okay. Now, I just used the word implied in the last case. This is a different type of implied thing. When you get a driver's license issued by the state of Texas, you are impliedly consenting that if you are stopped on suspicion of DWI and asked for a sample of your breath or blood, you will provide it. That's called implied consent. You may not realize that, but yeah, that's the case. Is implied consent enough to get your blood otherwise? We've had a lot of cases out of Texas in the past few years that say no, implied consent is meaningless. It allows us to suspend your driver's license when you fail to provide or refuse to provide a specimen of your breath or blood when asked to do so, but that's it. And several years ago, the United States Supreme Court weighed in on this. We had a couple of other states that were actually putting people in jail, one state up to a year, for failing to provide a specimen of breath or blood when asked to do so. The case is called Birchfield. It's out of the United States Supreme Court. I want to say maybe 2017, somewhere about that time frame. And it's a beautiful case. It's a long expose on the history of blood testing and DWI and the breath test, and what a wonderful test the breath test is, according to the Supreme Court justice that wrote the opinion. And interestingly enough, there's some dicta in that case that says that a blood test is more invasive than a breath test. And one day we may see something come out of that, but nothing has happened yet. Anyway, in this case, but what the Supreme Court said is you can't criminalize refusal to provide a specimen of breath or blood. You can make a civil penalty, such as forfeiture of a driver's license for a period of time, but you can't make it a criminal thing. So let's get back to Ruiz. Ruiz was driving and had a wreck. He ran away from the scene of the wreck, but he didn't get very far, and he was passed out or otherwise unconscious in a field nearby when the police came along and found him. They called EMS when they were unable to revive him to consciousness. EMS was also unable to revive him to consciousness, so they transported him to a hospital. And here's where it gets a little bit absurd. An officer shows up at the hospital and reads him the statutory warning that is required to be read before asking for a specimen of breath or blood after an arrest for DWI. Ruiz is still unconscious. Ruiz is laying in the hospital bed, unconscious, and the officer is reading this. I'm now asking you for a specimen of your breath or blood. Do you agree? Of course, he gets no response from the unconscious Ruiz, so then he tells the nurse, take his blood. We'll test it. Without a warrant. Should have gotten a warrant. He says, oh, it's okay. We had implied consent. And he didn't revoke his implied consent. And in this case, the Texas Court of Criminal Appeals says, you numbskull, he couldn't revoke his implied consent. He was unconscious. Consent that is given, that can never be taken away, is not freely and voluntarily given. Consent must be revocable. It must be able to be limited at some point. And so back to the old rule, get a warrant. Don't take people's blood without their consent. Don't read things to people who are unconscious and think that that's somehow going to get you to consent. It's not going to work. Get a warrant. Now we're going to deal with hotel rooms. And in San Marcos, Texas, at a Marriott Fairfield Inn, we have Tillman and two of his buddies smoking weed. Hotel staff changes over. New manager comes on duty. The old manager from the last shift calls the new manager and says, hey, those guys in that room are smoking weed. You need to go kick them out of there. So Tillman, knowing there's multiple guys in that room and not wanting to confront them himself, calls the police to get them to come kick the guys out of the room. Well, there's a little bit of question about whether that was proper or not. See, Marriott does have a no smoking policy in their hotel, but the penalty for smoking in violation of their policy is a fee, not eviction. They do also according to the manager on duty, have a no criminal activity policy, but that could never be produced in writing, so it's somewhat dubious. So the cops get there, and the cops and the manager are standing outside the room, and allegedly one of them smells marijuana. And but the cops tell the manager, look, we don't have a warrant. We don't have the right to go into the room, but you do. So the manager takes his hotel pass key and opens the door and stands back. And he unlocks the door, and then the cops push the door open. And when they do, they see a couple of guys, and they see anybody else in here. The guy said, yeah, there's a third guy. He's shaving. And that guy sticks his head out from behind the wall, and he doesn't have any shaving cream on his face. But meanwhile, they've heard flushing sounds. So the police are suspicious that maybe the guys are trying to flush their dope or hide weapons or something. And so they barge on into the room about 30 seconds after initially opening the door. Not knocking, not asking permission. Of course, the manager opened the door. Well, ultimately, they file a motion. Tillman gets busted for weed, possession of marijuana. He files a motion to suppress. And the issue that comes before the court is, we know there's an expectation of privacy in a hotel room, just like there is in a leased apartment or house. There's some expectation of privacy there. How do exigent circumstances work together with an expectation of privacy? And the Austin Court of Appeals did a fairly lengthy analysis of case history here, and they looked at what does it take to have exigency, what does it take to have probable cause. They looked at U.S. Supreme Court and Texas Court of Criminal Appeals case law, and they ultimately determined that to have an exigent circumstance justify going in without a warrant, there has to be a compelling need for official action and no time to secure a warrant. That's not what we have here. Well, maybe these guys are in there smoking some weed. We have an odor. You have to remember, human beings are not sensitive enough to detect the odor of marijuana with a reliable degree of certainty. Dogs are. That's why we allow dog sniffs and then searches based upon a dog alerting, a trained dog properly alerting, but not just human beings. There's other things that can smell like weed. We're just not good enough at that. We may be mostly right, but that's not it. There was no evidence here anybody was actually destroying anything. We didn't even know if they had anything in the room. And you can't justify a search based on what you find afterwards. You're like, well, we had a hunch, and sure enough, it was right. We found stuff. No. You've got to have probable cause at the time you go in up front. But really, you should just get a warrant. That's what the Fourth Amendment says. No unreasonable searches and seizures. Get a warrant. We only allow searches without a warrant when there are exigencies, and they just weren't present here. So the takeaway is you have privacy in your hotel room, and we can't just let the privacy be protected by the unfettered discretion of hotel employees. In here, the manager sure could have not opened the room. That'd have been great, but he chose to open the room, and rights were violated. We're not going to leave it up to that. Okay, this is a very quick little case. Idiot Wood flicks a lit cigarette out a window as he's driving down the road and does it right in front of a police officer who pulls him over for littering, and that's it. He gets a littering ticket, and he challenges this, and it goes all the way up to the Austin Court of Appeals. And Wood makes an interesting argument, and that's this case is published. He says, looking at statutory construction, one of the rules is the specific controls over the general. And he says, hey, in the littering statute, you have general littering, throwing stuff out the window, but then you have the more specific thing of throwing incendiary devices out the window that start fires. That's a more recent and more specific statute, and basically, because the legislature added that, they did away with the crime of just throwing a cigarette butt out the window, because a lit cigarette butt that starts a fire is something else. And so it's okay to throw cigarette butts out the window as long as they're not lit and starting a fire. And I didn't start a fire. And the Austin Court of Appeal says, no, that's not what was meant. That's an additional fine. Like, you throw a cigarette butt out the window, you're littering. But you throw a lit cigarette butt out the window and it starts a fire, that's arson. We're going to get you for an enhanced penalty under the littering statute, because maybe it wasn't intentional, maybe even not reckless, maybe it was, but there is certainly a separate punishment under the littering statute. But by no means did the legislature intend to do away with the crime of simple littering just for throwing a cigarette butt out. So it's still a crime. Throw a cigarette butt out your window. Don't do it. Johnson is an issue that the issue in the Johnson case is one that comes up quite often. Police interact with civilians and citizens and non-citizens and people in a number of different ways. if they see a crime being committed in their presence, or they have reasonable suspicion to believe a crime is being committed in their presence, they can stop you and detain you. It's an investigatory detention. It shouldn't last longer than is necessary to fulfill the purposes of the investigation and then go on about your business. Where we see that become a problem, for example, is when the officer thinks there's drugs in the car, but he can't prove it. He doesn't have enough probable cause to search, but he wants to get a dog brought out to sniff around the car and maybe get an alert and then get probable cause to search. So he keeps you on the side of the road for 30 minutes until the K9 unit can get there. That's not okay, because it doesn't take 30 minutes to pull somebody over and write a ticket. Pretext stops are legal in Texas. You can stop somebody that you suspected did something else wrong, but just stop them for the traffic violation that you actually did see. But you got to get their information, run the background check, make sure their cars tags are up to date and their license is valid and they have insurance, and then write them a ticket, write them a warning, let them go. Now you can ask them if they'll stay on the side of the road longer and talk to you or wait for a dog to get there. But if they say no, you got to let them go. That's when we talk about the reasonable length of an investigatory detention. But we also have lawful encounter. Of course, you have arrests and actual seizures as well. Those have to be supported by probable cause. Reasonable suspicion to detain, probable cause to arrest or to seize or search. But we have this other thing called a consensual encounter. Basically, just the same as I could walk up to you on the street and say, hey, how are you doing? Can I talk to you for a minute? Hey, I'm taking a poll for Texas Tech. Are Red Raiders going to win this weekend? Let's hope so, right? What do you think? You're free to say, buzz off. I don't want to talk to you. I got other stuff to do. I can't keep you from going away. The police are the same way. They can walk up to you. Hey, do you mind if we talk to you for a minute? Did you happen to see something happen over here? Or what? Or we want to talk to you about this. The courts and the law feel like people have a certain amount of fortitude, and they can say no to that, and they're free to go away. What happens is when we get in these gray areas, and Johnson is one of these situations. Johnson was parked in a park and ride parking lot in Houston, Texas, at night when there wasn't park and ride activity going on. And an officer notices this, says, that looks kind of suspicious. We know what people do in cars at night, in the dark, in out of the way places. They use drugs, they have sex, they do things that are inappropriate. I'm going to go check this out. And had the officer in this case just walked up to the window and said, hey, buddy, can I talk to you? What's going on? That probably would have been okay. In fact, there's plenty of case law out there that says an officer can tap on the window, can ask you to roll down the window or open the door. That's not detaining you. You're free to say no. They can even tap on the window to wake you up if you're sleeping in your car. They could even shine their flashlight in to wake you up if you're sleeping in the car to get your attention. This is not a detention. You're free to say no. You're free to go. But some things cross the line. What if they turn on the overhead lights? Almost always that's going to be a detention. Could be a situation where it's not, but most of the time that is. You're not going to feel free to leave if the red and blues are on. Well, what about that little spotlight that sits on the A-pillar? You can see it in the picture on the screen right in front of the side mirror on the driver's door of the sheriff's vehicle there. They can shine that spotlight on you. Are you free to go then? There's actually some case law on that where it's always a fact-specific situation, and you look at the totality of the circumstances in that particular case. What happened in the Johnson case was the officer pulls in, and in shining his light, or maybe it's just the headlights of his car in, he could see there's at least two people in the car and something's going on. And then he turns on the red and blues. And then he walks up to the car. He finds Johnson with his pants unbuttoned and unzipped. And ultimately, he found marijuana in the car. And Johnson said, wait a minute, this became a detention, not a consensual encounter. You didn't have reasonable suspicion to believe I was committing a crime at the time that you detained me. And the court agreed. This went too far. He could have walked up and encountered him, but when he turned on the red and blues, it became a detention, and he didn't know a crime was afoot at that point. Later, a crime was afoot, and he got evidence, but you can't get evidence after the fact to justify improper decisions before the fact. So we see lots of these cases year after year about these gray areas, and the more that we read them, the more that we get a feel for it and we understand it better. But the gist of it is you got to feel free to leave, and certain actions by certain officers are not going to make you feel free to leave. If you not feel free to leave, it's a detention. They got to have reasonable suspicion. Burwell is a case that we also see, a type of a case with facts that we see come up from time to time, and this involves a search by a private entity. Remember I said before, Fourth Amendment protects you from government action. In this case, we have Adobe Acrobat, Adobe software company. You may have Adobe software. If you read PDFs, you're probably using Adobe software right now, or you have it on your computer. And in their terms and conditions, at least in this case, They said, we will scan your computer and look for stuff. You're using our software to collect images. We're going to look at those images and we're going to look at documents from time to time. It's just what we do. So don't have bad stuff. Well, unfortunately for Burwell, he had child porn on his computer. And Adobe, through one of their random scans, found it, said, ooh, this doesn't look right, and notified the police, who got a warrant to search the computer. Burwell said, well, wait a minute, Adobe is acting as an agent for the police, therefore they should have had a warrant before they ever looked at my computer. And the court said, no, that's not the situation. The police didn't know what was going on. They weren't encouraging Adobe to do the search. They didn't even have any idea that it was happening. Adobe wasn't doing this for the purpose of creating a criminal case against Burwell. They just do this generally for everything. Under those set of facts, that is a private search. The government is not barred from using that information, and Burwell gets convicted of possession of child pornography, as he should. Okay, remember the legislature passed a law saying that we had to have legible signatures from magistrates, and the governor vetoed it. Well, this is a case where a magistrate was signing a search warrant, and they signed it with a crummy signature. It wasn't this one, but probably something that looked like that. Who the heck knows who that is? Unless you're familiar with that signature, you can't look at it and tell who it is. It's illegible. And there was no printed name. The search warrant was used to obtain the blood of Mr. Arellano to prosecute him for a driving while intoxicated offense. He moved to suppress and said, Texas Code of Criminal Procedure 18.04 specifies the contents of a search warrant, and it specifies in subparagraph 5, the magistrate's name appear in clearly legible handwriting or typewritten form with the magistrate's signature. Here, we only have a signature, and it's not legible, and there's no type or handwritten name, and so we don't satisfy the statute for the search warrant. But the court saved the case for the state because they said, wait a minute, there's reasonableness in everything we do in the Fourth Amendment, and in this case, there's a thing called a good faith exception. The magistrate messed up. He clearly authorized the warrant. He just messed up in adding a technicality by putting his legible name on there. But the police officer relied in good faith on the magistrate's actions. The police officer didn't violate Mr. Arellano's rights in any other way. And this was reasonable for the officer to have relied in good faith on this. And so it was okay. It will be an exception to the warrant requirement. All right, now we'll move to the Fifth Amendment. This protects your right to remain silent and not incriminate yourself. First case I'm going to go over pretty quickly. This deals with something called the dual sovereigns doctrine. This is a case that's been pending in front of the U.S. Supreme Court for quite a while. They had a lot of people watching it. What happened was Gamble was pulled over for a broken taillight. They searched his car and they found a gun and marijuana. Well, Gamble happened to be a convicted felon. He had a robbery conviction from 7 years prior that he had already served out his time on. But being a convicted felon, he couldn't have a gun. This happened in the state of Alabama. And Alabama prosecuted him under Alabama state law. He got a year in prison for being a felon in possession of firearms, served it out. And then the United States government came and prosecuted him for being a felon in possession of a firearm under federal law. And Gamble said, wait a minute, it's kind of like double jeopardy. Double jeopardy falls under the Fifth Amendment. And it's a dual, and the state said, no, it's not double jeopardy. It's dual sovereigns. He broke, by his one action, he broke both a state law and a federal law. And the state of Alabama is separate sovereignty from the United States, and they can prosecute their crimes. They can make their own laws, and they can prosecute them, and the feds can do the same thing. So a lot of interest in this case, and it goes to the Supreme Court. And the Supreme Court, in a 7-2 opinion by Justice Alito, said the dual sovereignty doctrine stands. And these are separate prosecutions by separate entities. That does not make it double jeopardy. Justice Ginsburg dissented. She said, we're talking about metaphysical subtlety here. This is ridiculous. Justice Gorsuch dissented, and he said, and I'm going to quote now, a free society does not allow its government to try the same individual for the same crime until it's happy. He said the majority's holding endorses a colossal exception to the ancient rule against double jeopardy. And that he says nowhere in the Fifth Amendment to the U.S. Constitution is the separate sovereigns doctrine appear. Of course, he was in the minority, a 7-2 minority. The law of the land is the separate sovereigns doctrine survives. So be careful. Some activity you engage in could be a crime in more than one overlapping jurisdiction. The Adams case is another double jeopardy kind of a case. But it's a little bit different. Let me explain. Two friends get in a fight. Adams is watching the fight, but for some reason he gets involved and stabs one of the fighters, and he stabs the fighter's brother, who's another bystander watching the fight. There were a lot of different stories told here. Both of the fighters told their stories. The brother told a story. There was a girl that told a story, and they weren't all consistent. I think it happened outside a bar, so the sobriety might have been an issue. Anyway, the state takes Adams to trial. They charge him with 2 aggravated assaults, one for stabbing the guy who was fighting, one for stabbing the brother of the guy who was fighting. And he goes to trial on the first case, and he argues a defense of self-defense. Not self-defense, defense of a third party. He says, Adams says, I stabbed this fighter to protect somebody else. And the jury buys it, and they acquit him. Well, then the state goes to try him for the stabbing of the brother of the fighter, and he says, wait a minute, I've already been convicted. I've already been acquitted. A jury found that I had the right to defend somebody else, and I acted properly. This is double jeopardy, and he files a writ challenging it. And the court said, no, that's really not the case. It goes all the way up to the Court of Criminal Appeals. They said these are really different facts, even though the first jury may have believed you were justified in stabbing the fighter to protect somebody else. That doesn't mean you were necessarily justified in stabbing the fighter's brother. You get to go have a trial on that. All right, the Sixth Amendment deals with your right to a speedy trial, a right to a trial by a jury, a right to confront witnesses and to have witnesses of your own called and compelled to testify on your behalf, and your right to have an attorney, a competent attorney, represent you. And that right to have an attorney also extends to the right to have an investigator to help that attorney. Oh my gosh, we are really running low on time. Okay, we're going to go fast. So this idiot lawyer is defending this woman accused of murder by being a party to her boyfriend killing his grandmother, and her lawyer wants to get paid along the way. He submits a bill to the court to justify his request for payment, and he reveals lots of confidential information. The state gets the information and uses it to prosecute her. They especially use it to cross-examine her mother, who was going to help her, but now can't because the state's crossing her. And she gets convicted. She appeals, and she says it was ineffective assistance of counsel. There was no reason for my client to disclose all that just to get paid. He could have waited till the end to get paid, or he could have requested payment without all that. And the court agreed. There was no reason for the lawyer to disclose that kind of stuff. That was crazy. Olabode said you shouldn't just introduce a probation file. I don't get to confront the witnesses who made the statements of the events that go into the probation file. And the court said probation revocation. I'm sorry, this is at a revocation of probation hearing. Is not a stage of criminal prosecution. The probation file can come in. The right to confront is different. In this case, Harrison was working operating a daycare center out of her home. She had a baby die. She didn't act right. When she discovered the 5-month-old little boy not breathing, she didn't call 911. She called her employee, who said, call 911. But she still didn't call 911. She called the parents of the little boy. They came. Boy still not breathing. She calls the employee again, who says, call 911. So finally, she does call 911. But somewhere along the way, she deletes some phone records and text messages to show what she was doing during this giant delay in time before 911 was called. Ultimately, the baby died. And she was charged with involuntary manslaughter and by omission. She had a duty to take care of the kid, and with tampering with evidence because she destroyed those records. She decided to plead guilty and go to the judge for punishment and hope that the judge might give her deferred adjudication. Her lawyer meets with the judge in chambers after the plea and says, hey, do you want some briefing on deferred adjudication in an involuntary manslaughter case like this? And the judge says, deferred on a dead baby? I don't think so. The lawyer doesn't tell Harrison the judge's statement. So when Harrison proceeds on to the revocation or to the rest of the sentencing hearing and gets sentenced to prison time, she says, and then later finds out that the lawyer already knew the judge wasn't going to consider deferred. That wasn't cool. That was ineffective assistance of counsel. There's a motion for new trial. The judge admits to making the statement, but he says, well, he was just shooting off the cuff. He was being a smart aleck. He really did consider the whole range of punishment. But how do you know? The judge that heard the motion for new trial, the trial judge recused and somebody else heard it. He believed the judge, and he denied the motion for new trial. But the court reversed on ineffective assistance of counsel because they said Harrison would have withdrawn her plea and gone to trial if she had known what her lawyer knew, which her lawyer should have shared with her, and that is, this judge ain't going to give you the verdict. So lawyers should not keep secrets from their clients. Let's see, we were just almost out of time, so I'm going to skip over. This is a strange case where one lawyer sued another lawyer. It's a really interesting set of facts. Got two cases here that don't apply to Texas. They're out of the Supreme Court. We had two other states, Arizona and Oregon, that allowed a conviction on a felony with only 10 of 12 jurors voting to convict. They could have a 10-2, 11-1, or unanimous verdict. That's ultimately been struck down. You got to have unanimous verdicts now. But if you have a mistake in one of those cases, then the Arizona Court of Appeals, in that case, got to review it and make the decision and not send it back for a jury trial on punishment. You got to love Yogi Berra. In this case, the person is a woman is on probation for assault. And while on probation, she commits a new assault by hitting her roommate in the head with an ashtray. And so she goes to a probation revocation hearing, and she pleads true. She admits she did that by pleading true to the allegation. Then the state decides to go ahead and prosecute her on the new assault as well, and she pleads not guilty. The state says, wait, you can't do that. You're collaterally estopped. You've already admitted it in your plea of true over here. And the court said, yes, she can do that, actually, because in a probation revocation, the standard is not proof beyond a reasonable doubt. It's a preponderance. There could be a strategic strategy to go ahead and let the revocation happen, but not marshal all your evidence and reveal your defense that you want to use at the subsequent jury trial. So you can plead not true at your revocation and still, or you can plead true and admit to something in revocation and still plead not true and make the state prove it up at a subsequent trial. I told you asset seizure and forfeiture did not pass, no reform of it, but the U.S. Supreme Court, in a unanimous decision, said Mr. Timms, who inherited $73,000 when somebody in his family died and used $41,000 of it to buy a Land Rover, which he then used in a drug deal when he sold $200 worth of heroin to an undercover cop, and he got his $41,000 Land Rover seized. The U.S. Supreme Court said that is cruel and unusual punishment. That's excessive fine. You took something from him that was worth way more than the value of what he was engaged in. It was worth way more than any fine that could have been handed down for his punishment. So no unreasonable seizures are going to be allowed. I just have run out of time, and I'm so sorry because I have probably 20 or 30 more minutes of stuff. But I so appreciate you being a wonderful and very quiet audience. I don't know if that is due to just great respect that you show or the mute button on Zoom. But either way, I am very appreciative of all of you and your time. And I will now look at the chat and see if there's any questions to answer there. And let's see. I don't see any questions. I see a couple of compliments. Thank you. You're very, very kind. Does anybody have any oral questions that they ask? And of course, you're free to go. I can't make you stay anyway. But does anybody have any questions they want to ask orally?
So I just wanted to let everybody know you can go ahead and unmute right now and feel free to ask some questions. I tried kind of undoing it myself, but you can go ahead and do that with your own microphones. I was excited to know that the red light cameras are gone.
or soon will be if there's a contract to run out.
Yeah.
Well, it was so nice to see all of you on the Zoom. And I hope we can do this again in person sometime. Maybe
seriously, yeah, Judge Hocker, thank you so much. I learned a ton, and I really, really appreciate your sense of humor too. It wasn't just a bunch of facts. It was really very engaging, and I appreciate that.
You're very welcome.
Very interesting.
Y'all have a good evening.
Thank you.
Thank you.
Bye, everybody.
Bye-bye.